my name is Shannon Salcido, and this is our rock group, Conundrum. This is for the Legal Environment of Businesses class, 2025. So I want you to imagine it's you. You are a fresh out of high school student, a musician in a band. The best thing in the world has just happened to you. Your band was approached by a record label. You were signed. You have a contract. You have all these really great opportunities coming your way. Then you realize that maybe this great opportunity wasn't so great after all. So here are the facts of the rock band case as we know it. The facts include the band signed a contract with a record label. They entered this contract before my counsel, so I was not there to advise. We don't know if they had counsel during this contract signing. The label is requiring 8 albums to be produced by the band, which includes the loss of intellectual property for the band. In other words, they lose the rights to the masters of their own music. The label can terminate the band at any time. However, there's no termination clause in the contract for the band to exit. We know that the band wants out of this contract, and we know that one way that that can happen is to acquire a large amount of debt and declare bankruptcy. So what legal issues does this bring forward? Well, first and foremost, acquiring a large amount of debt strictly to declare bankruptcy and then sever a contract would be considered bankruptcy abuse. This is not the purpose of bankruptcy. It was intended to dissolve genuine debt between creditors and debtors, not to simply acquire more debt. It is not intended for the rapid or sudden acquisition of debt. It is intended to stop the increase of debt and to help with reparations. This would be a perfect example of fraud, which is the wrongful or criminal deception intended to result in financial or personal gain. The intent here, intention, is the most important part. You are knowingly going into this, committing an immoral act. This contract is actually not valid because for a contract to be enforceable, there has to be a way for each party to exit, right? That contract termination clause. This contract specifically forbids the band from leaving, but the label may drop them, which automatically means this contract is not enforceable. There are some legal consequences here to consider. You could be looking at conviction under federal law, fines, or possibly imprisonment. So let's discuss ethics. Bankruptcy fraud and abuse. Well, ethically speaking, you have no intention of repayment. You're knowingly going to impact creditors. You're acquiring debt as a means of termination. Again, this is not the intention of bankruptcy, right? This is that intention of moving in, knowing exactly what you're going to do. You know you're not intending on repaying any of this. You know it may not even be necessary. You're looking at it as a way to manipulate your way out of another contract. Again, this is not the function of bankruptcy. This would be almost a poster child for bankruptcy fraud and abuse, in my opinion. Another ethical issue, this would be terrible, poor advisement or guidance of counsel. This entire process would be considered immoral. It will fail the reasonable person test. Counsel is required to maintain candor with the court. However, in this moment, you would be guiding your client towards potentially illegal activity. Your client's going to be stuck with long-term effects of debt, whether or not they declare bankruptcy. And then, of course, there's the intention of defrauding a court as well as your debtors or your creditors. So where does that leave us? In my opinion, my client, should file for legal contract termination, go through the court system, do this on the up and up. You could also try to enter negotiations with the label itself, maybe renegotiate the terms of your contract, such as the 8 record requirement or the 12-year limit. These are things that can be negotiated legally and ethically in a court of law. Thank you.